Hey everyone, I'm excited to share with you today a conversation with Daniel Michelson, who's a wicked smart attorney. And we have about a 45-minute conversation on estate planning, going in depth on some higher net worth items to look out for, but also trying to lay the foundation for just good long-term estate planning. I know it's not a fun topic to talk about, but it is a needed topic to discuss. And so I hope you find value in this conversation. As a reminder, none of this is legal advice. None of this is financial advice. He's not your attorney. I'm not your financial advisor, but hopefully you do learn a few pieces of information from this conversation. One quick technical note, there was an issue with Daniel's mic that we get situated here about 5 to 6 minutes into the video. So be patient and hopefully you enjoy. Thanks. Daniel, thank you for being willing to have a conversation today about estate planning. I'm sure many people have been losing sleep waiting for this conversation to happen. And now, all joking aside, really appreciate you being willing to come on the channel and have a quick discussion on this.
Yeah, thanks, Andrew. Happy to do so. It's the conversation nobody wants to have, yet everyone knows they need to.
Yeah. And so just to give maybe a quick background for viewers, listeners here, you are a practicing attorney right now and did your undergrad in Tel Aviv, worked for a very popular software for years called Riskalyze, and then you all had an exit after that, and now you're the managing director of strategic relationships with Encore Estate Planning, or Encore Estate. And you do that, is, so far as I understand, in conjunction with running your own private practice. Is that correct?
Yeah, that's right, Andrew. I got into this field after coming back from the Middle East and ended up working at that company, Riskalyze. Did that to fund law school at night. Ended up falling in love with the financial advisory space. Went into the estate planning world, and that's where I remain.
All right, man. So whenever I think about estate planning from a client's perspective, what I've noticed is just a misunderstanding of what it is. And many times people think, hey, that means I have to get a will and that's it. And it's kind of this opaque thing. So I thought it might be good to just have you explain in your eyes what estate planning truly is.
Yeah, good question, Andrew. And a lot of it comes down to we just don't know what's going to happen in life. And we need to have something put together so that other people know what's going on. Whether we are single or married, if we go into the hospital and we need someone to be able to talk to the doctor, need to make decisions, we need someone to talk to the bank. If we pass away, can people find my photos? Can they find my email? Do they know what businesses I own? I always ask people the simple question of, if you disappear, could someone step into your shoes and know how to work everything? And most of us don't even know how to make our own lives work half the time. How do we expect other people to be able to do that? And that's what estate planning is making sure things are in a place that is managed, that my children are going to be taken care of if I have any, and that when I'm gone, someone can come in and be able to manage that effectively.
Yeah.
And of course, the will, the trust, those are all parts of it, but only one component.
Right. So it's not, you and I were talking offline. It's not like what you see in the movie where they gather everyone in a big circle and they start reading off the will and saying, you're in and you're out and that kind of thing.
Yeah, as much as I wish it was, because my life would be so much cooler than it is, that's unfortunately not how it works.
So what are the basic documents that people need in place? And I'm sure this changes by life stage. So let me maybe put a little more detail on that question. Most of the people who listen in on my channel are going to be anywhere from 45 to 65 years old, married with kids, possibly grandkids, and on that verge of retirement, probably net worths, anywhere from 5 to 15 million. It all depends, but let's just use that as a backdrop for the type of person that may be listening in on this. What should they be, um, not them specifically, what should a person in that type of life stage be looking to accomplish with their estate plan and documents specifically?
Yeah, I always say the younger you are, the easier it is because you're going to continue acquiring assets and things are going to change. And I actually had a law professor describe estate planning similar like this. So people talk about probate all the time. They talk about the estate tax. What is that? I always say, okay, you have a Home Depot gift card, and every year it changes how much is on that gift card. So, for instance, it's, the $13.99 million right now. That's the federal estate tax limit per individual. You can combine that through portability with your spouse and double it. But right now, I'm single. I have 13.99 on this gift card. That's whether I'm gifting things during my life or when I die, anything left over can get used. And anything above that amount is what I pay estate taxes on. So if you're closer to that, 10, 15 and you're 45, 50, it's time to start distributing things out of that estate because you can do that in today's dollars, use a smaller amount of that gift card so that it's left over later. Most people don't need to worry about that fully, but if you are in that $7 to $12 million range and you're below, you're not retired yet, you should be thinking about these things. The bigger thing to think about is if you have children that are minors, you need guardianship in place. You need to be able to dictate who's going to take over if the kids are there. Another part of estate planning that you don't think about is you have children, they turn 18, they go off to college. You can't call their doctor. You can't talk to their landlord. You can't do anything related to finances or healthcare. So a lot of my clients I'll work with in estate planning and say, hey, should we get these documents in place? A power of attorney, healthcare directive, and HIPAA release. 3 simple documents for their children where you can help maintain their lifestyles and talk to the doctors, talk to anybody that you need to.
Yeah, most people. Go ahead, please.
No, I was going to say I'll put a little pause there and see any questions.
Yeah, I'd love if you could tease out a little more the fact that once your child turns 18, you actually can't go into the doctor's office and act on their behalf anymore.
Yeah. The minute you turn 18, whether we think of them as adults or not, they are their own independent person. You no longer have any legal ability to look into any of their affairs. Now, they need to decide they want your help to do that. They need to sign the document. But if you expect to be able to talk to the doctor, be able to assist them, you need to get these documents in place.
So from a document perspective, the normal things that you just mentioned, power of attorney, healthcare directive, guardianship, and then the, $10,000 question that I get from everyone is, Andrew, will versus trust. What do I need? What the heck is a will? What's probate? Is there trust revocable or irrevocable? My attorney says irrevocable, and it sounds crazy, right? So could we maybe just discuss, because I know you and I talked about this a few weeks ago, just some of the misunderstandings of will versus trust planning and making it an either or when it many times should be an and, especially now as estate planning is becoming more democratized.
Yeah, and a lot of it comes down to understanding when things take place. So to give you an idea, I describe it this way. Right now, everybody listening to this call, when you pass away, will have all of your affairs, all of your finances go to probate court. That is the court that handles all of the transfer after death. Now, every state has its own rules attached to that. They're called the rules of intestacy, meaning I don't pick and choose who gets what. Normally it's spouse and children, and every state has different rules around that, but they follow the rules of intestacy. So if I die and I have no documents in place, states differ on how long it takes and how expensive. In California, it's crazy. It is a very large percentage of the estate, and it's going to take minimum 8 months up to 2+ years to go through the process. I only can speak to California where I am. Now,
Right.
when I go through that, if I have a will and a will only, that might help to some things. I'm still going to go to probate court. I'm still going to pay the fees, and it's still going to take the same amount of time. But instead of using those rules of intestacy where they decide who gets what, I'm going to use my will kind of like a map. So the court's going to take that map and they're going to read out who gets what. We're still going to pay the fee, still going to go through the process of the court, but your wishes will go into account there.
Mm.
The difference between a trust is it's like creating a safe. So if you have a safe in your house, you have a safe in your office, that's great. And the safe is the trust. Now, the important thing is not just creating and buying a safe. You got to put stuff in there to protect it, right?
Yeah.
So that's when people talk about funding your trust. What in the world does that mean? That's putting stuff in your safe. For real property, you need to write and record a deed to get it in there. Business or beneficiary designations sometimes will flow from your accounts into there. That's where really the game is played of how do we connect things into that trust. But anything in that trust does not need to go to probate. You don't have to pay the probate court fees, none of that. I do want to make one distinction. People always talk to me about step up in basis for their property and say, I need to have a revocable living trust in order for my children to get the step up in basis for my home. That's actually not true. You're still going to get that step up in basis for all inherited property, but you are going to pay probate fees. And for California, $1 million home, you don't deduct your mortgage from that. So if I have a $900,000 mortgage on my $1 million home, I'm paying $50,000+ in probate fees for that.
Woo! That's not nothing, as they say.
That's not nothing.
Yeah. So you're telling me that the TikTok videos are wrong about needing a revocable living trust to get a step up in basis? I can't trust TikTok?
I wish I could trust it because I also do agree in almost, especially in California, most people trust is a good idea. So I don't want to push away from having people think about it. But no, they don't understand the tax laws.
So is there much difference in the intestacy laws state by state? Obviously, I understand you practice in California, but is there variation at the margin, or is it significant variation state by state?
So it's all pretty close together. So if you are married and you have no children, I don't know of any states where it doesn't all go to your spouse. But if you're married with children, that's where it kind of gets funny. If you have one child and then you're married, and again, it's community property state or not community property state, half goes to the spouse, half goes to your one child. If you have 2+ children, 1/3 goes to your spouse, 2/3 go to if you have 2 children to them, or if you have 10 children to them. So it doesn't differ that greatly, but there are community property considerations for a handful of states.
Yeah, and if your children are over 18 and you die intestate, I would assume they're just getting the funds then, or the property or what have you, right?
Exactly. And so all inherited property, I use this word community property. I don't know if anyone's in California or other states, that we are a community property state, meaning all money and money earned during your marriage is split. Whether you use, I laugh at my friends who I see are married and they Venmo each other. I'm like, if you get divorced, it's still getting split up between you two. But inherited money is always separate property, meaning if my parents die and I receive money that way, it's my own, even if I'm married. The problem is people will then put it into their joint bank account. Then it's hard to pierce that if they ever, get divorced. So a lot of people in estate planning is, protecting their children to be able to be effective as well. So if they just inherit it because you didn't do any documents, they're going to receive a lump sum. And then in all likelihood, if you didn't plan, did they plan? It's going to go into a joint account and it's going to get commingled and, likely be difficult to piece out any separate property for them.
Yeah. Can you speak to a little bit of, whenever I've talked with attorneys in the past, and let's say kids are, around my children's age, young, and so you obviously don't want them to get all of the money at 18. The rule of thumb has been something along the lines of age 25 a third, age 30 a third, age 35, the remainder of the corpus, right? And then there's what's called HIMSS provision, which you can speak to. Why is that the norm? Is that the best way to distribute assets to heirs, all else equal? Are there better ways that have kind of come into view recently? Do you mind speaking to that some?
Yeah, it honestly depends a lot on who is your family, what is important to you, right? A lot of it is cultural and taking everyone is individual, so being able to take that into account. Now, with that said, it's important to look at family and money and understand that who I name as my trustee, and the word trustee basically means if I have a safe, who gets the key to open the safe? That's the trustee. So when I pass away, that trustee steps in. They're the one with the code to that safe. They can look at what's in there and they can give out based on what my trust document says. It's not a favorite game. So just because you have an oldest son or daughter, that doesn't mean they should necessarily be trustee. We need to find the most responsible person. And if you don't have any, there's alternatives such as like corporate trustees, fiduciaries, where someone can step in. And the reason I'm talking about that in alignment with which beneficiaries receive, if it's outright, if there's time involved with it, is because children are often different. I can guarantee you, most people listening, if you have 3 kids, you would say they have varying levels of ability when it comes to saving money versus spending, being frugal or not. And so you can assign different rules to different children, but most people agree my 18-year-old should not receive X amount of dollars just immediately to them. And so why I talked about, outright distribution, the alternative is to create another trust. And you do that through your own documents. It's not difficult, but the document will say, hey, if I have 3 kids, maybe it's a third to all of them. And I don't want it to just go to them when they're 18. So I'm going to write, it goes into a sub trust for the benefit of my child. And I might want 25, 30, 35. That is really common. We also see people that say older. It depends how much money is involved with it too. So, we might do, hey, I want to give them, $50,000 the day they finish their undergrad degree or the day that they turn 25. And then I want the rest of it to be sprinkled out over the next 10 years. I would say that's less common. Most people I work with, they choose 3 to 4 different time periods and they distribute there. So 20, 30, 40, 30, 40, 50, or 25, 30, 35.
Mhm.
And
And
what all that means, Andrew, is it's going to go into a trust separate from their spouse if they're married, so that it's always going to remain separate property. That's the important aspect there.
right. And if it's a subtrust, it would also have creditor protection, correct?
Correct. Exactly.
Yep. And so during the life of that subtrust, many times there's also something called HIMSS, which healthcare, education, maintenance, and support, right?
Yep. 3 terms or 4 terms that have, hundreds and hundreds of things written about them. But the basics around it are just because maybe my children, I want it to be 40, 50, and 60 that they receive the assets. That doesn't mean they can't have anything. If I did 40, 50, 60, I probably don't have them named as trustee because I don't want the person who has to wait till they're 40 to have the keys to the safe. So I might have named, a third party or another family member or friend, but that person will be able to give money from those trusts for the children if it's for health, education, maintenance, or support. And you can craft that to be really strict, more lenient, but no one is going to be able to go to the doctor and not be able to get the money for their medical bills if they need to.
Can you help me understand what the heck the difference is between maintenance and support?
I would say that when we talk about maintenance and support, there are some fun cases that go into it because even now schools of thought are wondering if, do we even include it? Is it going to be valid talking about it? A lot of the support aspect and maintenance aspect, I wouldn't necessarily worry about distinctions with it
Mhm.
because the trustee is just going to use that within there. And that's where we start getting really deep into the weeds of what I think is actually valuable for if someone is really interested in it, we can absolutely dive into it, but it's more nuanced than, a quick podcast to jump into. But It's about if I'm in the hospital, if I need, maybe I have a caretaker and I need someone to jump in and care for that. There's just different, you're going to use one of those four categories to offer the funds for it.
Sure. Okay. Understood. And so another thing that I think about within the estate planning realm is, why is it so hard to get people to actually fund trusts?
I think the hard part about it is they do it quickly. Even as an attorney, right? Like we're very busy. Like that is, I know most people don't have documents done, but it can take a couple months to go through the attorney field and get all your documents done. And to be honest, no one wants to go to the attorney's office and do this. It takes some time and it costs some money, and you want to get out of there as fast as possible. And a lot of times you're handed like a funding guide afterward. The important thing is if you're working with an attorney, that is, the most in-depth way to get advice. It is probably the best solution. Now, you also can just work through an advisor often and still get documents created. But I would say why it doesn't get funded is if you only go to an attorney, you're not cluing in your financial advisor as well. You're not working together to be able to say, hey, as the attorney, I know you listed these things out. I'm going to tell you what you need to go do, but it's kind of on you. Versus if my financial advisor is all clued into this, then I'm able to work with them and go, hey, here's the 8 accounts we're working with. These ones need beneficiary changes. These ones can be owned by the trust today. And these ones, they're good as they are. So the important thing is if you don't have an advisor, you kind of have to play that role and be more vocal with your attorney and make sure you're getting it funded. If you own property and you haven't, or the attorney hasn't gone to the county that you own your property and recorded a deed, it is not funded. Make sure that that's being done. And then if you're working with an advisor, you're just going to be able to put that onus on them and say, hey, here's my bank accounts, here's my 401k, here's everything. Let's make sure it's all connected. It's not a one-time thing, because you're going to buy more things, sell more things over the next decade, 20 years. You got to also make sure those are connected to the trust.
Another question that I get asked pretty frequently is, when do you have direct beneficiaries on an IRA versus having the direct beneficiary be your revocable trust? Or let's assume your spouse, right, is the primary, and then having the trust as contingent rather than the ultimate heirs. What do you want to look out for when you're looking through the nuances of that?
So all of that comes down to it's a tax conversation when we look at that. So with the like an IRA coming through, I don't know if people have heard of the 5-year rule, the 10-year rule. That's something, ask your advisor about. That's a fun conversation to have. But when you look at that, if you receive money through a qualified account like that, through an IRA, you are going to owe income taxes at your tax level as an individual. So if I get a beneficiary distribution through from my parents or someone else, I'm going to pay income. So if I'm a high income earner, then I'm going to have a high tax rate for that. Now, the difference is that starting line for higher taxes and income is higher for a person than it is for a trust. A trust, it is very low. So income, if that money is flowing into a trust, I'm going to be paying a higher tax amount faster than I am as an individual. So high income earners tend to not do it that way. But it also comes down to control. So the two things you're really looking at are, hey, are they receiving any income anyway? Are they going to be paying high taxes? And also, am I giving it all to one person? Maybe it doesn't matter. Am I giving it to 8 different people and it's going to be harder for me to go with my different accounts, name beneficiaries for each one that are always going up and down? So if it's important for me for it to all be level and equal for all my children and friends, then it's harder to do that going through all beneficiary designations, because you can't control what goes up and what goes down. Versus if it all flows into the trust, they can use something called conduit language. So if anyone out there knows anything about electrical work, a conduit flows something to the other without it actually landing in what it's flowing through. A lot of times you can flow it through to the individual beneficiary to be able to pay the higher tax or the lower tax that's associated to it. The important thing with this is find a trustee that you trust to be able to handle this. That's the most important component to this. If you feel confused, you're in the same boat as every single other person. The important thing is if it's really complicated who's getting what, probably need someone to step in as trustee that is doing this professionally to be able to maintain that. If it's all going to one person, use a beneficiary designation. It doesn't really, you don't need to involve the trust for those types of account if it's all just going to one child.
Yeah, and so
Unless
what?
they're a minor, right? If they're not 18, that's where we get into the it depends all the time. So if they're minor, you don't want to have that happen.
Right. Then what I'm hearing from you is one thing you've come back to a couple different times. The trustee selection is incredibly important, and the guardianship selection is incredibly important. And the rest of these are details that it's going to be, facts and circumstances that
Yeah.
show whether it's good or bad in your situation. But if you have a trustee that's not the right person, you can mess up all of the good planning that could have taken place. Is that a fair representation?
That's exactly right. And don't worry about it so much today. The hardest thing is to get your documents done immediate, like getting this first part done. That might take you a couple weeks to work, with your advisor and attorney to get done, however you choose to do that. But it's a revocable trust. The basis for all estate planning is you're going to have a revocable living trust. All of the irrevocable stuff is about tax planning, about moving things. I talked about your Home Depot gift card in the beginning. That's where you're taking things out and starting to use those different gift cards from that place. But the revocable trust, you can amend in a day. It's really easy. You just add a quick amendment. So maybe you choose someone today to be your trustee. Don't think of that as set in stone. It's going to be a revocable trust most of the time to start, and you're going to be able to swap in and out people, as life changes over time.
Right. So let's talk about the amount that's on the gift card for a second. Everybody's
Yeah.
gift card, this is being filmed in May of 2025. If nothing changes, everyone's gift card is going to get cut by half at the end of the year. And so you mentioned a kind of the outset here, if you're in that 7 to 10 million range and you're on the younger end, you should really be looking at some of the estate planning from possibly the irrevocable side, but just understanding that you're getting closer to that threshold. So can you talk about what changes are coming up from the estate exemption side? And then also a little bit, the difference between your lifetime exemption and the annual exclusion, because that's something that I've noticed a lot of people get jumbled in their mind as well.
Yeah, absolutely. So what Andrew's referring to is the Tax Cuts and Jobs Act, which you probably hear thrown around for a lot of different things. And it's not only about the estate tax. That is one part of the Tax Cuts and Job Acts, though. And so if it expires as it's supposed to, meaning if the government does nothing, it expires, it goes back to the 6 something million plus inflation, so something $7 million range is what that's going to go down to. We have to see how that's going to go. But if that gets lowered, that's going to mean a lot more estate taxes for a lot of people.
Yeah.
Why this was such a big year for estate planners is because I have that 1399 gift card today. If I moved things into all these irrevocable trusts and I used that gift card, and let's say it did get lowered to 7 million next year, well, I've already used it from this year and I'm good. But if it gets lowered to 7 million, I can't go back in time and use that. But also, the important thing to know is these numbers change a lot. 25 years ago, it was 650,000 was the estate tax number. So the important thing is it's the year you die. So if, I'm in my 30s, and if I pass away in 40 years from now, who knows what the estate tax is going to be? So that's why it's almost this light. If I'm a high income earner and I'm looking at, millions of assets, I can start piecing things out. One thing a lot of people do is not worry so much about that big number, but they can use that annual exclusion that Andrew was just talking about. So this year it's $19,000 per person. So if I'm single, 19,000. If I'm married, we can both give 19,000 to an unlimited amount of people. I can give more than that, but if I gave $20,000 to you, Andrew, I'd have to go file a form saying I used $1,000 of my gift card. So I can give 19, and a lot of people will set up different trusts for their children, and they'll fund $19,000, or last year it was 18. This year they put 19 in it, and you can keep moving money into these accounts. and taking it out of your estate and whether it's for children or charities or whatever you want it to be. But you can do next year. We'll have to see where it goes. Right now, it's $19,000.
Mhm. And at minimum, probably what that does is it stops the bleeding, right? Because you're at minimum reducing the growth of the estate over time, or possibly, depending on your net worth, even decreasing it. And you're getting that growth as you gift the assets to the irrevocable trust. All the growth of those assets is out of your estate, correct?
Exactly. And there's different philosophy. There's so many different strategies you can work with. This is more on the higher level or high net worth planning. But like one really common one, you hear this term ILIT a lot.
Yeah.
It's about life insurance, irrevocable life insurance trust. That's all it stands for. And a lot of people use that annual exclusion to buy a piece of like life insurance for different children in their trusts. And that's an easy way to do that. They can also do that for themselves as a way to, they know they're going to be above that exemption limit one day. Well, the death benefit doesn't get included if you put it into an ILIT. So if I have a $4 million death benefit, I can use that to pay my estate taxes for everything else. So that's an easy way to use your annual exclusion to just think ahead for, the year that you do pass away.
Yeah, and especially like I live in Indiana, tons of farmers with very large farms in Indiana, right?
Yes.
And they've been in the family for 150 years. And if you tell them to sell the farm, they will not be happy, to say the least, right? And so an ILIT can be a way to provide liquidity to an otherwise illiquid estate also.
Yeah, and farmers, they have it really rough when it comes to the estate tax, probably rougher than anybody else, because most people, if you talk to the farmers, we know that it's not that they have 25% of that sitting in cash that they can go use. It's tied up in the farm. And I talked earlier about owning $1 million home, not lowering that mortgage off of there. So when we look at the fair market value of the farmland, that's going to be a big number most of the time. And they don't get to deduct anything from that to lower that. So if I look at all my farms and I go, this is worth $40 million, guess what? Your estate tax is going to be everything over the 1399 for that farm. How are you going to come up with 40% of that number?
Yeah.
That's where often life insurance will come in, because so many people get caught off guard. They never planned. My farm was worth 18 million, but I'm barely making payments. Well, that's a big tax bill for the heirs, and that's why small farmers are kind of lowering, is because this estate tax, this death tax for farmland is really, really hard if you don't plan ahead.
And it's based off the asset value, not net worth value, correct?
Yep. So you add, your estate is everything you own. You add up the fair market value and you don't deduct your liabilities from that. So that is unfortunately how that works.
Yeah. So if let's maybe broaden this a little bit from farmers to maybe just business succession in general.
Mhm.
What are some good rules of thumb? Let's assume you're closer to that 10-ish million range. Some good rules of thumb for business succession planning, and then also being able to provide liquidity to the estate. In the case of obviously dying or something along those lines, or incapacitation.
Yeah. A lot of times, you'll find it funny, the two people that talk about insurance the most are people that sell insurance and attorneys that do estate planning, because it does provide quick liquidity. I deal a lot with when someone dies and we need money to be able to administer everything, work through everything. It's nice to have that inflow of cash there.
Yeah.
But if I own a business, there's a few components to this. One, I want to make sure my operating agreement that I have with any of my business partners is understood. First of all, do I have a buy-sell agreement on that side? That's part of it. I also want to make sure, does my trustee know anything about my business? Are they going to be able to step in for me and administer it that way so that wishes are handled? So that's part of it. Maybe your trustee that you name is going to be different for the business than it is for everybody else. So if you're a business owner, you got to think, what's this business worth today? If it's a high number, then there is more that goes into that. There's deductions and things, and that's more nuanced that you're happy to talk to someone about. But you oftentimes will need to make sure that you have some cash available as well, because a lot of business owners also own real estate, also illiquid. So just make sure that your heirs don't come into something where they go, yep, this is all worth a lot, but how do I actually pull money out of it and be able to administer anything?
Yeah. If you have in the, I don't want to say impending liquidity event because that's a little too specific. If you have the inkling that there may be a liquidity event for your business in the future, how soon should you start planning and getting those affairs in order, especially if you know you're going to eventually be over the threshold, because
Yeah.
I've seen it so many times over the years where somebody walks into my office and they go, hey, I signed an LOI at a 10 multiple and they had just valued their business 6 months ago at a 3 multiple of EBITDA, right? And those are very, very different values. So what are some best practices if you know eventually I'm going to sell this business? How much in the future should you be planning to look at things like, there's so many strategies that we don't need to get into, but things like family limited partnerships, slats, donor advised funds, private foundations, all of these fancy things that you really need to understand fully. But as we zoom out, when should you start thinking of those things?
A lot of attorneys won't like my answer here because we like to, it's kind of like an artist, right? I want to paint the coolest estate planning picture that I can for you. And I get paid more the more that I get to work on your case and do things.
Yeah.
I will say, what's the value of the business realistically going to look like is always going to be my first question, along with everything else. So I'm going to look at that and I'm going to go, if you're only a couple $1,000,000 above the exemption limit, I'm just going to buy a piece of insurance. I go back to that. And let's not complicate this more than it needs to be. And let's handle it and be able to just pay the fees on it. Now, if we're way above that dollar amount, that's where we need to start kind of planning ahead. But if it's just going to be able to be handled by, an insurance policy for a few $1,000,000 to pay that, we don't need necessarily to go deeper. Now, the next questions come into, well, if I'm married, I always have to dig into how good is that marriage? Because some strategies we use when the relationship is really strong and we trust each other and there's less control for the spouse that's giving control to the other spouse, and we need to make sure that that's okay. If there's not really any trust there, then there's other strategies to go into. So it's about being honest with yourself of going, hey, this is my relationship, this is the value of my business, and what's the timeline associated to that. So the earlier you can, if you know it's going to be taking place, probably, hopefully you have at least a year to go through that, because if you call an attorney and you try to work through an estate like that, they're not going to be able to do it that month that you call them, probably even that quarter, because there's a lot more discovery and planning. You're going to have to do valuations of a business, which will take several months to do. So give them at least a year if you can to start planning for it.
Which is all the more reason to have those basic documents in order beforehand, because if you go to an estate planning attorney, you don't have that taken care of, they're going to say, I'm not even touching this over here until we get the first things taken care of.
Yeah, it's like your foundational base for estate planning. So everybody, we have our gift card, we have our estate value, and we have no documents. That's how we start. And so I'm going to come into this and I'm going to say, okay, maybe I'm worth $5 million. I'm going to start giving $19,000 into, to charities or different things to take advantage of. But most of it is I'm going to get my revocable living trust, a pour over will, which is all that means is the only beneficiary of my will is my trust. And the reason for that is it's like an oopsie document. Okay, I forgot to put something into the safe, which is my trust. Now my executor, my trustee is going to be able to use that pour over will, that oopsie document, to go to court so that we can hopefully get it back into the trust. So it's just an oopsie document. If you do all of your funding correctly, that pour over will never even be touched. But then you need healthcare documents, powers of attorney, in order to kind of maintain everything together. The powers of attorney, healthcare directives, those are for your lifetime. So if you're incapacitated, but as soon as you pass away, those documents kind of go in the trash. They don't mean anything anymore.
Mm-hmm. And you can deed LLCs or business interests to your trust as well at your death, correct?
Yeah. So there's different types of deeds. So there's transfer on death type deeds, meaning it's still owned by you. Everything's in your name. The minute you die, it transfers on death to whatever beneficiary. The hard thing with transfer on death deeds is if there's multiple people you're trying to give it to. So if you have 3 kids and you do a TOD, well, all three of those children, you have to basically be saying, I trust that all three of those will be able to travel to this county where the property is at my time of death and sign all the documents together and then agree upon what happens.
Yeah.
If you put it through a quit claim or a warranty deed and you put it into your revocable living trust today, you're not going to trigger, if that's your primary home, you're not triggering any sort of, um, the note's not going to get called due. That the laws are pretty clear on that. So you can put your home into your trust today. That way, all three children don't need to sign. Your trustee can sell and distribute or give it to one child. Whatever you write in your trust is going to be able to be handled.
Daniel, what changes do you see on the horizon and coming down the pike for estate planning, both from what attorneys are going to be able to do for clients, and then from a retail client perspective? Is there anything that we should be aware of?
So big things are estate taxes are always going to change. I even heard a lot of notes on, hey, is Trump getting rid of the death tax altogether, the estate tax? Who knows if any of that's going to happen? But what I do know is we all pass away. We all go to probate, and that's the way it works. And guess what? Probate is not fun, not expensive. Every state is different, I will say, and fees are different. All of that is different. But just because it's not that bad versus it's really bad, it still has bad written in there. So I just want to avoid that if I can. And working with attorneys is going to be now with all the technology coming into place, a lot of advisors are able to get those basic foundational documents done. I'm talking about if you work with a financial advisor closely, a lot of them can, if not themselves, through an attorney network, get you those basic documents. Do that. Just check that box right now. And then if you need to do higher level planning, you can always sprinkle that in over time. But just go spend the couple hours to get those basic things done. Advisors are much more tech forward than attorneys tend to be. So they have even cooler graphs a lot of times. If they're working with an attorney, you can tie them together, or if you're just working with an advisor. But I know Andrew's able to go, build it out and say, hey, here's where everything is. I make sure it's all funded and it's connected there. And advisors just have far better technology than the attorney network does.
Daniel, is there anything that we haven't hit on that we should for the good of the cause?
I would say no. I know it's not fun to talk about. I know it's overwhelming, but you are going to die. You don't want to give your children homework while they're grieving. You don't want your spouse to have homework while they're grieving, and you don't want them to pay the money that they're receiving while they're grieving. So it's not about you. It's about the family. And that's really what it comes down to. And just get it done. It's not that difficult, and you're going to be able to amend and change over time. But yeah, unfortunately, it's something that we all need to take care of because there is a plan written. You have your intestacy plan. That is your estate plan. But I promise you're not going to like it.
Yeah. Amen. I think that's a good note to leave on. Daniel, again, thank you for being willing to have the conversation. I think it's going to be very helpful for quite a few people and hopefully shed some light on the opaque estate planning industry.
Yeah. I appreciate you having me on, Andrew. And
Thanks so much.
my disclaimer at the end is, if you need legal advice, this is not your legal advice. Go ahead and talk to an attorney in your own state or get estate planning, documents done through your advisor networks that you already have.
Yeah. Well said. All right. Thank you, sir. Have a good day.
Absolutely.